Hello, I'm Ronnie Eldridge. Welcome to Eldridge and Company. Barbara Olshansky is the Assistant Legal Director of the Center for Constitutional Rights. Her work includes class action lawsuits concerning immigrants' rights, race discrimination in employment and education, environmental justice and public health, Native American rights, and prisoners' rights. She is part of the legal team the center has working on Rasul versus Bush, a lawsuit about prisoners' rights at Guantanamo prison. It's something that I'd like to start our discussion about. Hello.
Hi.
I am so horrified about Guantanamo and what happened and what's happening there. I don't understand it. In a country that has this sense of morality, we're told that the whole presidential election relied on people's sense of morality. We are running an institution like Guantanamo and doing the kinds of things we're doing. So that's why I'd like to talk about it. You're representing one of three, was it, British subjects?
Yeah, there were actually two British citizens and two Australian citizens in our case. The two British citizens have been released. They were actually released before the court ruled, and the two Australians remain in Guantanamo.
When did you start this? The center is such a remarkable place, isn't it? Do you all sit around, and how do you have the antennae to understand what it is that should be looked at and defended or
I think, you know, there are people that have been doing this work for a long time, like Michael Ratner and Ron Daniels at the center. And I think they're always attuned to what is happening and what the government is doing. And fairly soon after the government started reacting to the attacks on 9/11, it became clear that the position that was being taken when people were being arrested in Afghanistan and Pakistan was that we weren't going to comply with the Geneva Conventions. We weren't going to comply with international law. And once we saw that, very early on, we decided to bring this challenge, this habeas corpus, which really means you can challenge the legality of your detention. And we were only seeking, not the release of people, just to get them a very limited right to be heard by a court, any court, to get their foot in the door. And the Geneva Conventions say that when you're arrested in the battlefield, they're supposed to determine if you're a prisoner of war or if you're a civilian. And based on those determinations, you get a certain set of rights. And by saying that the Geneva Conventions didn't apply, the Bush administration was saying, we're not giving anyone any access to anything, no ability to make a claim, no ability to say, I'm a civilian, I was running an orphanage, for example, and I don't belong here. And we filed that fairly soon after the announcement came by the government about the Geneva Conventions. And so we filed it in February of 2002. And at that time, it was really not a popular case to file.
Right. And did you had the names of the people that you filed it for?
Yes, and that was very interesting. You know, the names came to us through human rights lawyers that we know in other countries, that in particular in Australia, this human rights lawyer, Stephen Kenny, had talked to people in Amnesty International, who in turn had worked with us. And the people in Great Britain had talked with another human rights lawyer who had worked with us. And the family members are the ones that came to us and said, you know, my son is in Guantanamo, and we would like to do something for him. And that's how it started.
So how many people, these are two British subjects and two Australian.
Right.
Weren't three of them, though, in England?
Yes. What happened is we brought this case only on behalf of a few people.
Right.
Our case got consolidated with another case, Al-Oda, which is on behalf of 12 Kuwaitis. And that's the way it went up to the Supreme Court. Once that was going up, we also did this very large outreach effort to find like other family members.
I ask you, how many people have been?
Well, this has been a tremendous effort. And, you know, people from our office traveled to many different countries, doing outreach to both the government in the countries, to non-governmental organizations on the ground, human rights organizations, and through that, more people came to us. And so now we have about 63 people that we represent in these cases, but that still leaves about 450 more there.
How many people are now at Guantanamo? Do we even know that?
No, we have a ballpark. The government has just refused to release the information.
It's complicated, so let's just start. So you filed the habeas corpus even before you had spoken, you spoke to the families, but you didn't know really what had happened in these cases.
Clients. No.
Then it went to the court. Which court did it go to first? The district court in Washington?
Yes.
And they said you were wrong.
Yes, so they said take a leaf out the window.
Right. And then you appealed it, and they said you were wrong.
Right.
And then you finally appealed it to the Supreme Court, and lo and behold, they said you're right.
Right. I mean, that was just amazing to us because, you know, we were arguing all the time that, you know, Guantanamo, the United States has run Guantanamo since 1903. And we said, you know, the lease with Cuba says the United States gets to do whatever it wants there. It looks like a mini New York. There's McDonald's, movie theaters, the whole thing. And the courts didn't really want to acknowledge that. And when it went up to the Supreme Court, we all thought, oh, we don't really have an ice cube's chance in hell. Just, you know, we didn't really have an idea. And when the court took it is the first time we had a little ray of hope because we thought, well, they're not going to take it to say the exact same thing. So maybe there's a little sliver of a chance. And, you know, I think we really can't take credit for the court deciding to take it. There were these incredible array of friend of the court briefs that went in with us, and
by this time everybody was in.
Well, it was really
because by this time we were in Iraq and all the different things that happened.
And people were starting to see that there was a problem with what the position with the the international community, that the United States had withdrawn itself from the world community of nations, and that was troubling a lot of people. And the Geneva Conventions and not complying with them were really troubling the military. So the briefs that went to the court in support of us were from retired Army generals, which just flipped me out. I mean, you know, that's not a usual constituency that I work with. People with all these medals and crew cuts, and that was great. You know, that was really great. And you know, diplomats, former diplomats, and secretaries of state, and a whole array of faith groups, and
this was before the scandal in Iraq.
Right,
broke
this was
out.
long before.
Right,
and like I think the one brief that made a difference was the brief that was filed by Fred Korematsu, who was the man who fought the internment of Japanese Americans during World War II, who stood up to the whole United States. And he fought, you know, when he submitted that brief, and he's very elderly and very ill, the next day the Washington Post had this unbelievable editorial that said, "The conscience of the court speaks." And that, I think, was what made the court listen. And and I think that is what helped us.
The first action was simply that the people who have been arrested know what their charges are?
You know what their charges are, and get a right to contest them.
Right.
And to say, you know, I was fighting for an army of the Taliban, which was a legitimate government. I should be a prisoner of war. I was completely innocent, and, you know, here's my proof, and you should let me go. You know, I wasn't so innocent, and I took up arms, and I should, you know, and you have to try me.
So how did we get to the second court decision, which just came out this month?
This was really interesting. That decision in Rasul opened the doors to the courtroom. But that's really all it did is, you know, we got our foot stuck in the door there so it couldn't close. And what we've been doing since then is moving forward with these cases.
After the first decision, though, then they set up military tribunals?
Yeah, they actually started setting up these tribunals in Guantanamo, and this was a very insidious thing. Once they knew that we had the right to go into federal court, the government didn't like the idea of, you know, being shown up, that there were people that were innocent there, that they didn't, you know, do what they were supposed to. So they quickly created what we call the Wolfowitz hearings, these combatant status review tribunals, which you go into them or with the government already saying that you're an enemy combatant, that you're an unlawful soldier under any term, and you have to prove that you're not. And you can't have any witnesses. Although they said you can, they've not let any witnesses, no documents, you can't have a lawyer. They wouldn't let us advise them before they go in. And the translators have been terrible. And so, you know, these people are lost. And what they come out with is a finding by the government, yes, we were right, you're an enemy combatant. And what they hope to do is take that piece of paper. And when we get into federal court on, you know, an individual's case, say, to the court, you have nothing else to do, you just look at this paper, you say it's okay, and then they're done and they stay there forever. And one of the things that's been really horrific in this process is at the same time there are these tribunals, there are these full-blown commissions, which are all before the military, which can result in the death penalty. And there's no appeal to a civilian court. It goes just to the president. And so that looms. There's a number of people that have been designated for that. And, you know, what's so amazing to me is we have both our regular civilian courts here, our federal courts, and we have a whole set of military justice courts. And that the president didn't choose either of those, but chose to create one that doesn't meet the requirements of either. And this, I think, is what has really upset the armed forces in the United States and why they're with us, because they say, we have this system of justice. You know, the Geneva Conventions are incorporated in our code, and why are you creating something that doesn't meet any of these standards? And that's really what we've been battling. And that case that came down, that decision that came down last week, was the first challenge to those military commissions that said, you can't do this. We have a military code. This is how we address these things. You can't, you know, create the death penalty and enforce it without giving anyone a review, without giving them the opportunity to see the evidence against them.
So do they have counsel?
They're allowed counsel, but counsel can't be present in the court at all times, and they don't get to see the evidence, you know. And that is what everyone objected to. And the court said, you're right to us. They don't get to do this. This completely violates our law. And the president didn't have the authority to create that new system in the first place, which is really, goes to the heart of it, that, you know, it's this incredible cynicism, if you ask me, this lack of faith in our democratic institutions that our administration, the presidential administration, doesn't have. You know, I believe in our courts. And why am I arguing against like an administration that doesn't have the faith in our courts? And that's what is amazing to me.
So who designed this plan? Wolfowitz and did Gonzalez help with it?
I think there is
counsel to the president, who's just been appointed, is nominated to be the Attorney General, is the author of the memorandum that's so famous about torture and about not following the Geneva Conventions.
And that is, I think, one of the things that scares us the most, because I think I was really, you know, terrified by the actions of John Ashcroft, because I think he just really thought the Constitution was a piece of tissue that, you know, you blow your nose in and you throw it away. And you know, Mr. Gonzalez, I think, is in some ways more dangerous. Someone who calls the Geneva Conventions quaint. Not only...
He did that in his memorandum.
Not only... And he also solicited this memorandum about torture, about how to get around the definition of torture in the law, and what defenses you could raise to torture. And I think, you know, even if you don't think that this is like a terrible moral position, just from our own like belief in humanity and human nature, what it does is it undoes all of the law that we've created since the end of the Second World War that establishes boundaries for how we conduct ourselves when there are hostilities.
There was so much coverage and so much outrage expressed by the atrocities in the prison in Iraq. But the same things, it seems to me, happen in Guantanamo. Is that not true?
It is true.
And for our viewers, you have a website, and on the website you can link to different things, or, you know, pull up different things. And one of them is a 115-page memorandum describing, in the words of the two people you're defending, right, or that you're representing, that describe how they were arrested in Afghanistan, taken to Iraq, brought here in Guantanamo, and the conditions they live in. I could not stop reading it. It was beyond anything I've read. It was so horrifying to me. The conditions in Guantanamo, have they changed?
We are having a very hard time. You know, we have very limited access to Guantanamo. And when we go down there, you can only go and meet with your one client. So, and we are not, one of the classified areas of information is what are the conditions of confinement. We can't get down there to find out. No. We rely on the International Committee of the Red Cross.
And they have their own political pressures.
And they have their own rules about not being able to tell us. So it's only when it gets so egregious and the government is so recalcitrant will the ICRC stand up and make a public statement like they did earlier in Guantanamo, which was almost unprecedented. It had to be really bad for them to say this. And you're right, you know, what happened in Guantanamo, in some ways Guantanamo, which occurred first, was like a laboratory
of
what happened in Abu Ghraib. Yeah. And all of those things did go on there, and they are horrific. And it took us a long time to get the young men that came out of Guantanamo to talk about what happened to them. It really took a long time. I think they had to see and understand that other people were willing to talk about what happened in Abu Ghraib to feel okay.
They could do it. They're kept in cages. They're not. They're deprived of things. They're humiliated. I mean, they're tortured. They're threatened. They're everything. And what also is so interesting in these memos, and I hope people really look at it. Do you know what site they look to?
It's actually it's the testimony of Shafiq Rasul and Asif Iqbal, and it's a report that's in their own words, and it has pictures associated with it that are done by an artist for them describing some of the things they had to endure.
It's just gripping, and it's something people should see. But it also illustrates the complicity of other groups. I mean, it isn't just the military who's running that. That's a military base. But it's the different agencies, the CIA, the FBI, who else? It's a lot of different agencies that come in and do that.
Yeah, and it's why that, you know, when you're getting to that very critical point that, you know, the administration has said it's just, you know, these are rogue actions of a few individuals. And, you know, the memos that came out, the 50 or so memos that came out really give the lie to that, as does the cooperation of these other agencies. You know, the CIA very clearly had a hand in hiding people from the Red Cross. Everyone that's arrested in military combat has to be on a list that's given to the Red Cross. And Rumsfeld admitted this finally, that he had worked with the CIA to authorize holding people outside so the Red Cross could never see them. And that means, you know, that goes all the way up the chain of command. There's no question. And then, you know, the question for us is like, how could we not hold these people responsible for something that I don't think the American people really believe and approve of this. I just don't.
Well, they can't, but I don't think they understand it. I really don't. The other case that is so interesting is the Canadian who was detained at Kennedy Airport on his way back to Canada from Europe, who landed up in Syria because our government knew that in Syria they would use torture. Is that really?
I know, it's really, I have to say, it's really shocking. It is a shocking thing. It really is. And this case, he was really just changing planes in JFK the way everyone does, going home to Ottawa. And the government refused to, like, he was born in Syria, but, you know, he left before he did military service. His family left because they didn't like the regime. They were politically active. You know, they moved their life to Canada for a reason. And when he said to the government here, you know, I don't know what you think you have of me. There's nothing. Maybe I'm confused with somebody. Don't send me to Syria. I left there so I wouldn't have to serve for that government. Don't send me there. The United States refused to listen to him, and they're obligated to under the Convention Against Torture, but they didn't. And for 10.5 months, he was really brutally tortured there.
Now, the Canadian Foreign Service operated in much better faith, it seemed to me, than the British Foreign Service did with the men in Guantanamo. The British are just, they were terrible.
They're operating side by side with the United States.
We're going we're using up so much time. I want to know what brought you into all of this kind of law and what? And I know that you clerked for one of the most interesting people, Rose Bird, who was the Chief Justice in California. So would you tell us a little bit about it?
Yes, she was really my hero and my role model. I graduated really not sure whether I wanted to practice law. I just felt like a misfit. You know, I was from the island of misfit toys, and I didn't know what I was doing. And I, through like sort of tumbling backwards, ended up clerking for her. And she was this wonderful person that was plucked by Jerry Brown to be the Chief Justice. And She served an incredible tenure, really fighting for people's rights in the most concrete way. And what she said to me is, you know, one day she pulled out her chair on the bench and said, "Sit here." And I said, "No, I can't." And she said, "Yes, sit here. And let me tell you, you can do this, and you can make a difference. And even if you don't sit in my chair, you can still make a difference." And I don't think I would be doing this if she hadn't conveyed to me that through the law, you can try and help people, and you are sometimes successful at it, and that it means something to people. And you know, that really, when I worked with her when her tenure was over, she said, "Let's find you a place where you can do this." And it took me a while. I did good work at other places, but, you know, I ended up at the Center for Constitutional Rights, which is, you know, I know, even though she's passed away, that she would be smiling knowing that this is what I'm doing. And I, you know, one of her disciples ended up at this place.
Yeah, her philosophy, though, is diametrically opposed, isn't it, to the standards that President Bush says he wants to impose on his judicial appointments?
Yeah, I mean, it's just, she really...
And the whole center, the Center for Constitutional Rights, believes in using the law for social benefit, right? And social change.
Right, for social change. I mean, in trying to help people, the people that are the most disenfranchised, that have the most difficulty in this country, whether it's the poor, the elderly, you know, communities of color, or just the everyday working person. All of those issues are, you know, the court, as it's been, you know, changed by conservative administrations, has really moved toward rolling back civil rights. And, you know, we are really trying hard to push against that and to still push forward to make sure people can live, you know, a happy and healthy life in this country. And that's, we are diametrically opposed to the administration.
Let's go back. Is the district court in D.C., is that known as a conservative court? Is that more of an example of what the Bush administration likes?
Yeah, it is a conservative court. And what's interesting is the one judge that we were before the first time around, when we went up and we lost miserably and then lost miserably again, when we won in the Supreme Court, Judge Kohler-Catelli was really great. The day after, she called and she said, "I've heard from my superiors." And she said, and even though, you know, my jurisdiction, my power hasn't come back down to me because it has to come back down through the court. She said, I understand, I agree that this is how it has to go forward. And she turned to the government and said, "How are you arranging for Miss Olshansky and her colleagues to go down to Guantanamo?" And I think they were just speechless. And you know what, even though she is by no means, you know, a liberal out there pushing this issue, she's a very, you know, moderate judge. She said, this is what the law is. And that was very heartening to us. And in some ways, even the conservative judiciary has been on our side, because the administration has been telling them for the last 4 years, you don't get to tell us what to do. But in fact, they do. And the way that you know, the separation of powers operates is the judiciary gets to look at the executive and say, what you're doing is unconstitutional. And that battle has worked to our is very, very important and has worked to our benefit. You know, judges, I think, have been pushed too far by the administration and are now saying, you know what, you don't have a blank check, like Justice O'Connor said in the Hamdi decision. You might think you get a blank check in running this war, you don't. And that is, I think, where the courts have played a critical role and still can in reining this in.
But if we have appointments that reflect or in the tradition of Alberto Gonzales and some of the nominees that have been held up in the Senate,
those are nominees that are not inclined to play that check and balance role. And that's where our concern is. It's really not so much if you're Republican or Democrat. It's, are you a constitutionalist? Do you believe in those checks and balances? And when we oppose judicial appointees, it's not because they have some party affiliation. It's because they're fundamentally, you know, not holding their faith to the Constitution. And that's what our real concern is. The way, you know, the actions of Gonzales are. You know, when he was talking about torture or about not obeying international law, that's violating the law of the United States. And how can we have an attorney general that is so willing to violate United States law? That's the critical question.
Did Ashcroft have a role in that whole thing? Not as much, right?
Not as visible in the memos that we have now, but in crafting the policies under which we arrested people without cause. Yes, in instructing people to basically lie to us when we went to prisons to find out who was arrested. They told us no one's here, and that has now been documented by the Department of Justice itself. Its own internal audit division, the Inspector General's office, said, well, yes, in fact, the policy from the Ashcroft's office was to tell people to lie to their lawyers and to lie to foreign consulates. And that is, that's alarming.
How many people have been arrested in the United States? Do we know? We don't know.
We're never going to know.
Tell us, the website is?
ccr-ny.org.
And people should definitely go to that. What's next in your defense?
In our defense, we are really working hard now to try and get the names of the remaining people that are in Guantanamo, so that they, that they can get the benefit of the Supreme Court decision as well, and at least get their day in court. And that's really what we're working on. And we're also working on these cases about the abuse that happened in Iraq.
And what can people do to support that?
They can support CCR, certainly. We could always use that assistance. They can, if you come onto the website, there are also things that we suggest about how they can be active in these issues.
How are you funded? Can we do that in 10 seconds?
Yes, it's really private donations at a very few foundations. We don't take government money. We don't take corporate money. And so it's individuals like you and me that support our work that, enabled us to go to the Supreme Court and really enable us to do these things that we think are in, the name of American people.
Well, thank you very much, Barbara Olshansky.
Thank you for having me very much.
And please go to the website, read the testimony of these men, and understand what we're doing. It's really very frightening.